The state of Colorado just lost its attempt at regulating an ICE detention facility. So today on August 20th, the district court just said that the law that was passed recently create better inspection standards at ICE facilities, it was unconstitutional. We're talking about HB 26-1276. It was a law that was passed to do three things at one specific ICE detention facility, basically the only one in the state. It's called the Aurora ICE Processing Center in Aurora, Colorado. So the three things it does is Section 2 provides that the county inspectors can go in on a discretionary basis. The judge said that was fine because county inspectors have always been allowed at all different types of prison facilities. It didn't really change anything. It just kind of clarified the statutory language that was already there. The other two provisions in the law, though, were very, very specific to this one ICE facility. And so the judge warned that one of the provisions, which was currently inactive, which was a reporting requirement that the facility had to do annual reporting on different conditions like the temperature averages, how much access they had to food, how much access they had to worship services, how much access they had to legal counsel. All of these reporting requirements weren't currently in effect. And because of that, they said that we couldn't enjoin them. But in the future, if they ever took effect, which could happen, then the judge heavily implied that they would also be preempted or they would be a violation of the supremacy clause. So if they ever became effective, they could get an injunction for them. Now, the one and only provision that was in effect and that did get enjoined during this court decision was a provision that required the state inspectors, specifically the Colorado Department of Public Health and Environment, to conduct mandatorily one inspection every 3 months. So that's four inspections a year, unannounced. They had to be provided full access to the facility. And if they were denied access, the facility, Aurora, could be fined up to $50,000 depending on court action. So that specific provision, the judge said was preempted because it only really targeted one facility, a federal facility, which was the ICE facility. Now, this attempt that states are currently undergoing to request or to demand higher standards at civil detention facilities is ongoing. There's another case in the Ninth Circuit in Washington State, also involving Geo Group, and also with a law that may look neutral on its face, but is actually targeting ICE detention facilities. The way they're worded, and honestly, I've looked at both. One is worded very generally, which is actually the right way to do this, when they're basically targeting all detention facilities in the state. And this specific Colorado one, they specifically focused on immigration detention facilities. The only people who can do that are the federal government. And for that reason, it seems like it was properly enjoined. Thanks for listening. For more on this, go to The Migration on Substack.